Hello, everyone. My name is Melanie O'Brien, and I am the manager of the National NAGPRA program. And this is the monthly webinar for July 2024. Thank you all for joining me today for this webinar. Let's see, the 8th, I think. No, 7th in our webinar series for the year. We have 3 more webinars after this one. As a reminder, we have changed the date for the August webinar to the first Friday of the month. So August 2nd will be the August webinar. And that will be followed then by a webinar on the 3rd Friday in September and October to finish out the year. We appreciate all of you who have joined us or watched recordings of these webinar series over the year. We look forward to continuing this in next year, beginning in January of 2025. And we welcome your thoughts and ideas on this webinar series and topics for future webinars. Please share that information with us through our webpage, through our email address, which is nagpra_info@nps.gov, and that's NPS for National Park Service. I will send that to everyone in the chat, but please email us with your feedback or your thoughts, as well as your ideas for future webinars. As a reminder, we will take Q&A at the end of the presentation through the Q&A portion of Zoom. You will not be able to ask your questions live or raise your hands. So please don't raise your hand. We are unable to manage the webinar and hand raising at the same time. But please ask your questions through the Q&A in the webinar. I will turn that on when I finish the presentation. So on to the presentation for today's webinar. The topic for today's webinar is Indian groups without federal recognition. And I've prepared a short presentation to discuss this issue in the revised regulations. And then we will, of course, have plenty of time for questions after this. So, as you're all aware, the regulations were revised at 43 CFR Part 10 earlier this year. In January of this year, they became final. These were a full revision of the implementing regulations to clarify and simplify the previous rule. The regulations apply to all museums, as that term is broadly defined under NAGPRA, and to federal agencies. There are 2 different regulatory processes under the regulations, one for protection of human remains and cultural items on federal lands or tribal lands, and the other process for repatriation of human remains or cultural items by museums or federal agencies. We're going to talk about both processes today, and I will distinguish them generally by these terms. These are the titles, abbreviated, of the subparts in the regulations. So subpart B is protection of human remains or cultural items on federal or tribal lands. So we've abbreviated that to be protection on federal or tribal lands, and you'll see that in the heading of the slides. And subpart C is the repatriation of human remains or cultural items by museums or federal agencies. And again, we've abbreviated that here, and you'll see that in the heading of the relevant slides. As a reminder, and as has been presented before in this webinar series, as well as other places, there were departmental priorities that these regulations respond to. Primarily, the Department of the Interior, or DOI, was interested in clearing a path for expeditious disposition and repatriation through the revisions to the regulations. The overall goals for the regulations were to clarify and improve these processes, to provide a step-by-step roadmap with timelines throughout the regulations, and to better align the processes with the Act and congressional intent. In addition to those overall goals, the department was also interested in ensuring that there is deference to Native American traditional knowledge, which is a newly defined term in these regulations, ensuring that recognition of the rights that are afforded to lineal descendants, Indian tribes, and NHOs by the Act are reflected in the regulatory language. And lastly, to incorporate input from Indian tribes and NHOs to the maximum extent possible in the final regulations. So again, this is just an overview of what the priorities were for the department in drafting and finalizing these new regulations. Again, as I've presented in other places, the comments on the proposed rule, the largest number of comments on the proposed rule, covered these different topics. And you can find the same table in the final rule itself, just on the first page or two of the final rule. We included this summary of the major comments that we received on the regulations as they were proposed in 2022. Again, the largest number of comments we received were on changes to cultural affiliation or affiliation as it was in the proposed rule. And the second place, or tied for second place, topic for comments was in the role of Indian groups without federal recognition, which is the topic that we're going to discuss today and look a little bit more in depth at those parts of the regulation and in particular the final rule and what it reflects. Again, within the first couple pages, maybe the second page of the final regulations, there is a list of the major changes in the final rule from the proposed rule. And the second item in that list of major changes is the removal of references to Indian groups without federal recognition. And that the final rule has removed those references and prioritizes the rights of federally recognized Indian tribes throughout the disposition and repatriation processes. And then there's some specific citations there to where that is reflected in the final regulations. And this is the major change that we're going to discuss today. And I've pulled together actually more from the final regulations to illustrate this change. The proposed rule did include references to Indian groups without federal recognition and provided options. Although limited, there were options in the proposed rule for Indian groups without recognition to achieve a return of human remains and cultural items. But that has been removed from the final regulations. And I should add, it was removed as is discussed in further based on comments that the department received. Again, remembering that this is the second largest number of comments that the department received on the proposed rule. We note in the final rule that this change emphasizes and recognizes that the Act reflects the unique relationship between the federal government and Indian tribes and NHOs. That's citation is to the Act itself. NAGPRA 25 USC 3010 is a reference to that unique relationship in NAGPRA itself. And this change from the proposed rule to the final rule is also based on experience over the last 13 years with repatriation involving Indian groups without federal recognition. And that experience, as those of you who are very familiar with NAGPRA and its history, at least over the last 15 years, that experience comes out of the 2010 rule on culturally unidentifiable human remains and the disposition process that regulation provided since 2010 that included involving Indian groups without federal recognition. Again, on each slide, I've included where you can find this statement in the final rule, the paragraph, and then a direct link to that paragraph. We will provide the PowerPoint along with the recording of this session on our events page at the conclusion of this. So there are 4 comments in the final rule that really address the question of Indian groups without federal recognition and their role in the process for repatriation and disposition. And I've highlighted those here. Comment 3, comment 39, comment 91, and comment 114. Again, this is captured in a table at the very beginning of the final regulations. So if you're interested in this information, you can find it right there on the second page of the final rule in a table 2, where you can find the comments that relate to these topics. And as a note for you who may not be as intimately familiar with the final rule as I am, when you go to the final rule on the Federal Register, you can easily search for a comment number by typing the number, a period, and the word comment, and it'll take you right to that, or at least to references to that comment. Hopefully it's an easy way to navigate, but this gives you also a guide to finding those comments. I first wanted to address the issue of cultural affiliation, in part because it comes at the beginning of the regulations in section 10.3, but also because this is where we tend to see some of the most confusion, at least in conversations or questions that we get about the role of non-federally recognized Indian groups or Indian groups without federal recognition. A lot of times, the first question we receive from a museum or a federal agency, mostly from museums, is that there is an Indian group with cultural affiliation. And our response to that question or assertion or statement is that's not really possible. The definition of cultural affiliation itself in the Act and in the regulations only applies to Native Hawaiian organizations or Indian tribes as that term is defined, so meaning federally recognized Indian tribes. We reiterate in the final rule in this paragraph that's here on the screen that an Indian group without federal recognition may have a shared group identity to human remains or cultural items, but that Indian group cannot have, by definition, cannot have a cultural affiliation to those human remains or cultural items. This is an important point of language, but it is significant as we often see it plays out in the repatriation process or disposition process, where an Indian group or a museum or a federal agency, in looking at the question of cultural affiliation, cannot really consider an Indian group in that analysis, in that decision making. That's not to say that Indian groups are excluded from the process. And I want to be very clear at the very beginning of this webinar that Indian groups are not excluded from the repatriation or disposition process. As is the current practice prior to these new regulations, Indian groups without federal recognition can and have very successfully worked with federally recognized Indian tribes as a part of a joint request for repatriation. That option is still there. It's not written in these regulations, in part because these regulations do not make requirements of Indian tribes, federally recognized Indian tribes. It is up to the federally recognized Indian tribes to decide how or if they want to work with Indian groups without federal recognition. Therefore, the regulations don't require it in any way or even mention it, but it is certainly an option and has been an option and continues to be an option. But again, it's incumbent upon the tribe with federal recognition agreeing to work with the Indian group without federal recognition. Looking at the first subpart B, protection on federal or tribal lands. Again, the header here indicates which subpart we're looking at, as well as the citations at the bottom of the slide. So in 10.7, we have removed the option that was in the previous regulations to transfer human remains that are unclaimed to an Indian group without federal recognition. So that is the main change in the final regulations from the proposed and from the previous rule, is that option for transfer of unclaimed human remains or cultural items, again, from federal or tribal lands to an Indian group without federal recognition has been removed from these regulations. But we have retained the option for a federal agency to transfer human remains or cultural items to an Indian tribe or NHO, or to reinter them. Now, it's important to know that this transfer or reinterment is at the discretion of the federal agency or the Department of Hawaiian Homelands, again, because we're talking about federal or tribal lands here, and after following the requirements in 10.7. It is a discretionary act, and the regulations do not and cannot dictate when or where reinterment occurs, but it is the option that's provided for unclaimed human remains or cultural items under subpart B. And again, you can find this statement in the final rule in paragraph 422, and you can see the process in 10.7D. Turning to subpart C and the repatriation process by museums or federal agencies, you will hopefully see that this is similar. And both processes and the reasoning in both processes is very similar. And the process of either protection or repatriation is very similar. And we tried to ensure that those two processes aligned at least as much as we could in this section. So again, we have removed the option to transfer human remains or cultural items to an Indian group without federal recognition. So a museum or federal agency cannot, under these regulations, transfer human remains or cultural items to an Indian group without federal recognition. I'm going to say that one more time. Under these regulations, a museum or federal agency cannot transfer human remains or cultural items directly to an Indian group without federal recognition. This is a change in from the proposed rule into the final rule and from the previous regulations. The change was made in response to strong objections that we received during the comment period from federally recognized Indian tribes. That's discussed further in comment 3, if you'd like to see that. We have retained the option to transfer to an Indian tribe or NHO or to reinter. That again is a discretionary act by the museum or federal agency, and there are certain requirements, but human remains or cultural items can be transferred or reinterred as opposed to repatriated. And we're going to talk in more depth about this process today. In the final rule, we provide an example, actually 2 examples for why we are providing this process in the regulations. As we have learned in the past 13 years, in Texas, for example, we are aware that there are often conflicts between the federally recognized Indian tribes and Indian groups without federal recognition. And the result of those conflicts are actually in a preference, in many cases that have come to the NAGPRA Review Committee. There has been a clear preference for reinterment by the museum or federal agency rather than a transfer directly to the Indian group. In California, another example here, that state law provides for more involvement of state recognized groups in repatriation. And in many cases, Indian tribes have worked jointly with Indian groups without federal recognition to complete repatriations and reburials. So we are aware that in California, in many cases, where the state law requires additional consultation with state recognized groups, that repatriation has been achieved through that collaboration between federal tribes and Indian groups without federal recognition. And that is why we've provided in the final regulations in 1010K for any Indian tribe or NHO to request and to receive physical transfer of human remains or associated funerary objects that have no cultural affiliation. We hope that this will allow for even more collaboration between federally recognized Indian tribes and Indian groups without federal recognition to achieve ultimate repose or rest for those human remains and associated funerary objects. So again, while a direct repatriation to or transfer to an Indian group without federal recognition is not provided for in these regulations, we are hopeful that that federally recognized tribes and Indian groups without federal recognition will be able to work together to achieve successful returns and repose. In addition to transfer to an Indian tribe, again, a federally recognized Indian tribe, reinterment is an option for museums or federal agencies. And again, like that transfer, is a discretionary action. The regulations don't provide any additional requirements on reinterment. There's no requirement about when or where it would occur. The regulations do not require identification of a location, but do require that sensitive information, which may include where human remains are reinterred, be protected from disclosure. As requested by the NAGPRA Review Committee during the proposed regulations, we conducted a thorough legal and policy review of this paragraph at 1010K for allowing for reburial. And we determined that neither the review committee nor the secretary must review agreements between parties prior to publication of a notice to transfer or reinter. As many of you may be aware, under the previous regulations, prior to a reinterment or prior to a reinterment or a transfer to an Indian group without federal recognition, required that the museum or federal agency present their request and their agreement to the review committee, and then the review committee provided their recommendation to the Secretary of the Interior. We have removed that from these regulations. So there's still the option for reinterment, but it no longer requires a presentation or review by the review committee or the Secretary of the Interior for a museum or federal agency to proceed with the notification of their plan to transfer or reinter. So the specific process that's provided for in 1010K for, again, repatriation by museums or federal agencies, and this mirrors very much what is in subparts B on federal or tribal land. There is a paragraph of the regulations in 1010K related to human remains and associated funerary objects, and it only pertains to human remains or associated funerary objects for a museum or federal agency to transfer or reinter. The first requirement in this paragraph is for those human remains and associated funerary objects to have no lineal descendant and no Indian tribe or NHO with cultural affiliation. So the first step is that there is, the museum has, or federal agency has completed the inventory process, published a notice of inventory completion that finds there is no cultural affiliation and no lineal descendant. And then 1010K could apply. But I said could apply because this is discretionary on the part of the museum or federal agency. Nothing in the regulations obligates a museum or federal agency to transfer or reinter human remains or associated funerary objects. It is a voluntary action by the museum or federal agency. If the museum decides to do this, then there are 3 steps to the process under 1010K. First is to agree to transfer or reinter. The second is to submit a notice for publication in the Federal Register related to the transfer or reinterment. And then the final step is to complete it, to transfer or reinter. Again, I want to stress that the first part, even before you can engage in 1010K or the discretionary act, is the required act of publishing a notice of inventory completion. And a notice of inventory completion must include a determination related to lineal descendants or cultural affiliation. It is possible through the inventory process, which I will add includes consultation, For a museum or federal agency to determine that there are no lineal descendants and there are no Indian tribes or NHOs with cultural affiliation. You can find this described in the step 5 for notice of inventory completion. And really in that step, it's a reference back to the inventory itself, which is where the determination must be made that there is cultural affiliation or that there is no cultural affiliation. So that notice of inventory completion must be published, even where the determination is that there is no cultural affiliation. This is a change in the process from the previous regulations. Previous regulations, again, required museums make this decision about cultural affiliation, but did not require the notice of inventory completion to be published. Now, a notice of inventory completion is required to be published, even when there is no cultural affiliation determination. So once that notice is published, then a museum or federal agency must wait at least 30 days for any requests for repatriation that might be received in response to that notice of inventory completion. So again, a notice could be published that identifies no cultural affiliation to a federally recognized tribe. And that provides an opportunity then for an Indian tribe or NHO that disagrees with the museum to make a request for repatriation. And the museum must then engage in the process to resolve those requests before it can proceed. If the first notice of inventory completion is published, there are no requests for repatriation, and that 30-day window passes, then a museum or federal agency, if they agree to the discretionary act of transferring or reinterring, can submit a notice of transfer or reinterment for publication in the Federal Register. They must then wait another 30 days after that second notice before they can transfer or reinter. While we haven't published any notices of transfer or reinterment under the new regulations to date, we have published a couple of notices of inventory completion in that first bullet there, where there was no lineal descendant or no Indian tribe or NHO with cultural affiliation. I think we've published, perhaps today we published 2 additional ones, so I think we're up to 4. This is the first one that was published in May of this year, and it is a notice of inventory completion by Monterey Peninsula College in Monterey, California. And we have a template available for this kind of notice on our website. And you will see, those of you that are familiar with the notice of inventory completion template, you will see that this is a little different. First of all, it requires a list of those parties that consulted. It requires identification of the 3 parts of a cultural affiliation decision and what information the museum has related to that. And then lastly, and probably most significantly, is in the determination section, the template requires that the museum state that there are the number of human remains, but that there are no lineal descendants and there are no Indian tribes with cultural affiliation. And then you can see below that is the more standard language from a notice of inventory completion that provides for the opportunity for requests for repatriation from lineal descendants, Indian tribes, or NHOs that can show lineal descent or cultural affiliation. So again, the notice of inventory completion here is to announce the decision by the museum that there is no lineal descendant and no cultural affiliation, and to provide an opportunity for Indian tribes or NHOs that disagree with that determination to provide that request for repatriation. So this is an integral step to transfer, and you may all be wondering what this has to do with Indian groups that have no federal recognition, and I promise to bring it back to that. As you can see in this notice in particular, there are a large number of Indian groups without federal recognition that were involved in consultation. And it is possible, although we don't know yet, but it is possible this museum will be publishing a second notice, either to transfer to an Indian tribe, a federally recognized Indian tribe, or the museum may choose to reinter the human remains or cultural items, and there will be a notice of of reinterment. So once a notice like this is published, then the options for a museum or federal agency are to transfer to a federally recognized tribe or to reinter. And it is our hope that, again, our hope that this will resolve these human remains and associated funerary objects and provide for a path forward. And while that path forward is limited in work with a federally recognized tribe or in reinterment, it's not, there's not no option, I guess, is the point. There are options here, and there are two options. I want to stress that, I'll step back here. Okay, so in agreeing to transfer human remains or associated funerary objects to a federally recognized Indian tribe, there is no requirement for that federally recognized tribe to have cultural affiliation to those human remains. So this provides an opportunity for any federally recognized Indian tribe to support and work with Indian groups that do not have federal recognition to support the process of repatriation. Likewise, it provides the opportunity for the museum or federal agency to decide to reinter human remains or associated funerary objects, but does not provide any other requirements other than that the museum agrees to do the reinterment. Who is involved in that reinterment is up to the museum once it's made that decision and I will say published the notice of reinterment. I'm going to conclude my presentation by making a reference to the other part of repatriation, and that is the repatriation of cultural items, so not human remains or associated funerary objects, what is sometimes referred to as the summary process and is in section 10.9. There is no similar process in section 10.9 for transfer or reinterment of cultural items. The reason for that, again, goes back to the definitions of cultural items themselves and the requirement for the identification of cultural affiliation for a cultural item to be a cultural item. So, for example, a sacred item under NAGPRA must be culturally affiliated to be a sacred item under NAGPRA, culturally affiliated with a federally recognized tribe. If an object in a collection is not culturally affiliated and is not connected to, or I should say, is not culturally affiliated, which means it is not connected to a federally recognized tribe, then that is not a cultural item under NAGPRA, and NAGPRA does not require repatriation of that item. A lot of times we get asked about this. What about sacred items that belong to an Indian group without federal recognition? Well, if an item is sacred to an Indian group, it is very likely it is not a sacred item under NAGPRA, meaning that it's not connected to a federally recognized tribe. However, we would encourage a museum to be sure that they're consulting with federally recognized tribes before they make that decision that an object is not a NAGPRA item, meaning not connected to a federally recognized tribe. And then the options for what a museum does with that item is not subject to NAGPRA and would be subject to other ways that museums have of transferring or deaccessioning their collections and would fall outside of NAGPRA. So there's not a parallel process for cultural items because of the definitions of cultural items themselves. So I'm going to conclude there. I'm happy to go back and to look at any of these items. I'm going to stop sharing and I'm going to turn on the Q&A. Please be patient with me, as I think you all know I'm running this myself. And All right, you can now ask your questions in the Q&A. You can also upvote questions. So if there's a question someone asks and you have the same question, you can then upvote it to raise it to the top of my Q&A list. And again, I want to ask you to please do not raise your hand. I'm unable to manage hand raising in the large number of people we have in attendance, and I need to have your questions asked in the Q&A. This also helps us. I'll say it's not just it's not just a matter of management. It is a big part of that, but it's also because this allows us to have a record of the questions, and we can use that in formulating more of our frequently asked questions and some of our other guidance. So it's very helpful for us to have a written record of your questions. So please ask your questions in the Q&A. I will read them before I answer them. And I will also thank everybody in advance for your assistance in answering questions that you can. For example, someone asked if we can share a link to past recordings, and someone else shared the link to our events page. So thank you for the question. Thank you even more for your support in answering the question. Okay, so let's dig in. Remember, again, you can upvote, you can add any question. I will do my best to get through them and to answer as many as I can. All right, the first question. I just want to really, really be sure I understand. Any federally recognized tribe, regardless of cultural affiliation, can assist a non-federally recognized tribe with, I'm going to say, with receiving human remains. Yes. If the museum or federal agency agrees, first. If the federally recognized tribe agrees, second. And third, the museum completes the 2-notice process. So any Indian tribe can participate in the transfer part of 1010K. So human remains and associated funerary objects can be transferred under 1010K to any Indian tribe or Native Hawaiian organization. So that could mean that where human remains are not culturally affiliated, that an Indian tribe across the country could request transfer of those human remains and cultural items because there is no cultural affiliation. And a museum could agree to that. There are no other requirements than that the Indian tribe make the request for transfer. What the Indian tribe, the federally recognized Indian tribe, does is up to that federally recognized Indian tribe. The museum cannot require that they work with a certain group. The museum cannot put any conditions on that request for transfer. But a museum can agree or not agree to the transfer itself. So I hope that's clear. Yes, and again, remembering that there is this 2-notice publication process to provide, remember, the point is to provide ample opportunity, or at least 2 opportunities, for an Indian tribe with cultural affiliation to come forward. Again, I think that as we see these notices be published and this process play out, I think it might be easier to understand. But I want to stress again that this is not necessarily new. This is what we've seen happen over the last, well, at this point, 14 years under what the previous regulatory framework under culturally unidentifiable. Yeah, thanks for the next question, because I made the change myself and I wanted to explain it. I'm gathering that transfer is not the same as repatriation, or those 2 words that mean the same thing. They do not mean the same thing. And we are very careful in the language of the regulations to use repatriation to mean something specific. Repatriation is a defined term in the regulations, and transfer is something different. In fact, in the regulations, we only talk about physical transfer Except in 1010K and 10.7, when we do talk about physical transfer to another tribe. So transfer does not mean repatriation. Repatriation means, in the regulations, that a museum or federal agency, let me get the link. I don't want to mess up the words, because we were very careful in the language, obviously, that we used in the regulations to be hopefully clear. Repatriation means the museum or federal agency relinquishes possession or control of human remains or cultural items in a holding or collection to a lineal descendant Indian tribe or NHO. So as I described, cultural affiliation by definition is only about a connection to a federally recognized tribe. Repatriation means, again, that relinquish of possession or control to a federally recognized Indian tribe. So repatriation does not mean the same thing as transfer. Repatriation requires cultural affiliation or lineal descent under these regulations. Transfer to a federally recognized tribe under 1010K is not the same as repatriation because there is no cultural affiliation. I hope that helps. I realize that it can seem a bit exacting sometimes, the language choice, but I find that it's helpful in ensuring that we're all talking about the same thing to ensure that we're using the same language. Great, thanks for the next question. And this has come up very recently. If you are repatriating to a federally recognized tribe that is partnering with a non-federally recognized group, should they both be included in the repatriation statement? That is a good question. Our advice, well, first of all, let me step back. Before the repatriation statement, of course, there needs to be a notice, either a notice of intended repatriation, a notice of intended disposition, or a notice of inventory completion. And it is our recommendation that the notice itself not include the non-federally recognized group. However, we are aware that in many cases is the preference both of the museum, the federally recognized tribe, and the Indian group to have the Indian group identified in that notice. We have a couple of examples of where we fit that language in. It's under the request for repatriation section that we can provide for that. And if an Indian group is identified in the notice, we still would say the Indian group should not be identified in the repatriation statement. And again, we understand that this is perhaps against the preference of a museum and the consulting parties. But when it comes to a repatriation statement, the document that is relinquishing possession or control, we think that it is very important that the museum only identify the federally recognized tribes in a repatriation statement. So while Indian group may be included in the notice, and we would really encourage you not to include them in the repatriation statement, if you must, if the museum and its consulting parties are insistent, then again, we would recommend you take that language from the notice and fit it into the repatriation statement. But again, it's important that the process is clear in what a museum is doing in relinquishing control, possession or control to a federally recognized tribe. I will add that this is a good topic for discussion among museums and those that have confronted this or dealt with it and how they've resolved it. All right, the next question is, can federally recognized tribes, nations, pueblos, or NHOs argue that sacred items are defined as such on behalf of non-federally recognized groups? Can they claim cultural affiliation with said items in order to satisfy that definition? Um, an Indian tribe or NHO can request repatriation of any human remains or cultural items that it is culturally affiliated to. Cultural affiliation can be broad. It can involve multiple federally recognized tribes. It could involve multiple earlier groups. There are certainly plenty of examples of cultural affiliation where an Indian tribe, a federally recognized Indian tribe, makes a request for repatriation of a sacred item, in this example, based on its cultural affiliation and its understanding of cultural affiliation to that item. Could the Indian tribe also recognize that there is an Indian group that has a connection to that sacred item? Absolutely. We have seen a lot of success in different parts of the country in these sort of cooperative, collaborative relationships between federally recognized tribes and Indian groups, and have proceeded in this way for decades. Even before the culturally unidentifiable rule, this was happening in many parts of the country. Probably one of the best examples of this is in the Columbia River Plateau, where the federally recognized tribe and Indian groups have worked together for a very long time in achieving repatriations. So absolutely, but I want to stress that information does not need to be a part of the federally recognized tribe's request. A federally recognized tribe has standing to make those requests for repatriation of a sacred item on its own directly to a museum without any additional information or justification about their relationship with an Indian group. Okay. There's a question. We just resort, make sure I'm getting all of the most upvotes. Again, remembering you can upvote questions. To clarify, if an indigenous belonging cannot be culturally affiliated to a federally recognized tribe, is not subject to NAGPRA in California, and museums must go through other means, perhaps CalNAGPRA, to transfer items to a California tribe that is not federally recognized. Yes, that's an accurate statement. I guess the emphasis here needs to be on that determination of cultural affiliation, or the identity of an item or an object as a cultural item. If a museum is deciding that this is not a cultural item that is culturally affiliated to a federally recognized tribe, it can certainly do so. We would again encourage you to be sure that you've consulted with the federally recognized tribes on that decision, that you've made them aware of your decision, that this is an item that does not subject to NAGPRA, and that you're going to follow some other process. Because again, remember, the risk there or the issue there is in making that decision, the museum might have failed to comply with NAGPRA if in fact that item is culturally affiliated to a federally recognized tribe. So you just want to be very careful about that decision-making process when you're deciding that something does not fall under NAGPRA. And I want to stress again, this only applies to cultural items. Human remains and associated funerary objects that are Native American are subject to NAGPRA. Let me say that again. Native American human remains and associated funerary objects are subject to NAGPRA, period. There's no exception, as there is when we're talking about sacred items or objects of cultural patrimony and cultural affiliation. Okay, another question about transfer or repatriate, and I hope I addressed this. But let me just say again, and we said several times in the regulations and in the final rule, that physical transfer the physical movement of human remains or cultural items from a museum to a tribe is not repatriation. Repatriation is the process by which a museum relinquishes any interest in the human remains or cultural items. So again, this is all very much related to the discussion in the regulations, in the definition of possession or control, and what the act itself was doing when it recognized the rights of Indian tribes and NHOs to human remains or cultural items. This process, this regulatory process, is about resolving those rights, going through the process to acknowledge those rights. And that's why it's different from physical transfer. We do use the term physical transfer in a couple places in the regulations, and it is different than repatriation. Okay. Great question. I'm going to come back to the one that's kind of outside the scope right now, but I will get to it. Can you comment on how NAGPRA may work in conjunction with states that have separate processes for repatriation to Indian groups? For example, CalNAGPRA, in relation to repatriation to California recognized but not federally recognized entities. Thank you very much for this question. It is a significant one and an important one, and one that I have been talking about in California for the last year in a lot of different venues. I have done at least 3 presentations virtually in California with the Native American Heritage Commission, which is the state entity that oversees CalNAGPRA. And we have worked to try to ensure that we're messaging in a unified way, or at least a collaborative way, on how CalNAGPRA and NAGPRA work together. Actually, more than a year ago, I developed a CalNAGPRA document, which is available on our webpage, and I'm going to ask if somebody can find it and put a link in the question to that, because while it's prior to these regulations, it's still very applicable. In that, CalNAGPRA, as I understand it, requires consultation with state recognized tribes. CalNAGPRA also expands the kinds of museums that are subject to CalNAGPRA, but that does not conflict with the requirements in the federal law for consultation with federally recognized tribes and the repatriation to federally recognized tribes, or the process. So I guess in answer to your question, we see between at least myself and the Native American Heritage Commission a lot of conjunction and collaboration between CalNAGPRA and NAGPRA. In fact, if you look at CalNAGPRA, which in its state law, state code, it's very clear that the requirements of the federal law must be followed. So, I think we see a lot of connection. Thank you so much, somebody, for finding the link. I really appreciate your help. It takes a village, right? To run a webinar. So thank you very much. So hopefully that answers your question. And I would say, if you have specific issues in California related to this, please reach out to me, and we can provide information on the federal requirements, but more importantly, probably reaching out to the Native American Heritage Commission to help you with the requirements of CalNAGPRA would also be very important. Okay, let me just resort. Okay, there's a question in the chat that I just wanted to read, especially for those of you that may be on the phone or only listening. Remains and objects uncovered on state or private land, and the state has regulations permitting repatriation. Is there any conflict with NAGPRA? thanks, Stephen. Stephen references the requirements under NAGPRA in Subpart B for disposition on federal or tribal land when there is a discovery or an excavation. And that the definition of tribal land does include all land within the exterior boundaries of a reservation, which could include private or state land. The second provisions are for those human remains or cultural items in the possession or control of a museum would require repatriation. And then a follow-up question about if a state agency that receives federal funds assumes possession or control of Native American human remains from non-federal or non-tribal land, they are required to comply with the repatriation provisions of NAGPRA as well as their state law. They would comply with both provisions until there is an actual conflict, at which point federal law would generally preempt state law. Stephen responded that that is correct. Again, I'll just add that that's going to depend very much on the state law, what the state law requires, and it is in the decision of whether the state agency has possession or control that this hinges. So it is important to keep, while these are general questions and a general response, the particulars in these cases are very important. Right. Again, I want to encourage you all to ask questions related to the topic of Indian groups without federal recognition. I'm happy to answer any questions that we receive, but I do want to clarify that the topic for today is Indian groups without federal recognition. The next question is for ancestors that are located in the collection and are found in collections with no information, but are likely to be Native American. Can they receive an affiliation of Native North American while the institution conducts more extensive consultations to determine how to repatriate these individuals? So first of all, let me provide you all with a glimpse into my brain. Brace yourselves. The first thing I do is look for indications of what section of NAGPRA we're talking about here. So this starts out with for ancestors. So we were talking about human remains or associated funerary objects in this case, and that are located in a collection. That means we're looking at museums or federal agencies and the repatriation requirements under 10.10. Number one, that's how I always analyze a question before I start thinking about what my answer is. All right, so for human remains found in a collection with no information, but that they are likely Native American. Your first step is actually to consult. Well, your first step is to make a list of those, but what you've written here is a list, right? And you don't have any other information to add to your list. So your second step is to consult. And yes, through consultation, you need to try to identify cultural affiliation. Now, that process must be completed within a certain time frame. Under the initial law, there was 5 years from 1990 to 1995 to make your list and to consult and to decide if there was cultural affiliation or not. We have reset that same timeline starting in January of this year. You have 5 years to do the same thing, to consult and to decide if there is cultural affiliation or not. Now, I think what you're asking here is, can cultural affiliation be to all federally recognized tribes in the United States? That's possible. I think that you could make a decision depending on consultation in particular. I will point out that we state in the regulations that acquisition history is a part of the cultural affiliation decision. And what I think you're talking about here when you're talking about found in collections really is acquisition history. And so while you say that there's no information, there is information about where these human remains are located today. And maybe you know at least how long they've been located there. maybe you don't know when they were received. We often see that this is the case, that say a museum has a very uh, old collection with very little information about when it received certain items in the collection. But it does know that, say, in 1962, they did a full inventory or cataloging of the collection and identified those at that time. Well, then you know, at least since 1962, those collections have resided in your museum, in your location. That is information that you should use to start the consultation process. This question actually was just raised in the community of practice listserv. And I responded by providing citations to a couple paragraphs in the regulations, thank you, that talk about found in collections. So I would recommend you take a look at that. Thank you for sharing the link to that paragraph 503 that talks directly about this circumstance and this issue. Again, remembering that there is information available and that information may be limited, but it's what you need to use when you make your decision about cultural affiliation. Okay, the next upvoted question is, in the past regulations, there were only 2 Native Hawaiian organizations. Now there is a very long list. Are we required to submit a summary to all the groups listed on the NHO list? Well, I would actually say it's incorrect to say that there were only 2. There were 2 NHOs that were named by name in the law, and those names were repeated in the regulations since 1995. But the definition of a Native Hawaiian organization is broader than just those 2 organizations. So while 2 were named, the definition of an NHO is broader. There is a longer list, and to the extent possible, a museum must try to identify which NHOs are potentially culturally affiliated, and it is those NHOs that you would share your list with. If you don't know which NHOs might be culturally affiliated to the objects in your summary, you could send it to the 2 named NHOs. You could send it to some of the NHOs that are broadly serving all Native Hawaiian islands. But generally, NHOs and the regulations provide for ways of narrowing consultation in Hawaii based on location. So where you know which island, for example, the cultural items were removed from, that may limit the number of NHOs that you would send your summary to. Okay, the next question is, if there's a disagreement between decisions under state law, such as NAGPRA, and then federal law, what steps must be taken? Yeah, I guess it would kind of break down here to the nature of the disagreement, who is in disagreement, and how that is in conflict between state or federal law. Again, I think that we see in my office in the National NAGPRA program and the Native American Heritage Commission lots of collaboration and cohesion between the state and the federal law, and don't see a lot of conflict other than around this issue of Indian groups without federal recognition. And the NAHC has been very clear in the consultation requirements are broader under NAGPRA and include Indian groups without federal recognition, where obviously the federal law does not require that consultation with Indian groups, but it does not prohibit it. So again, we don't see a conflict there between the 2. And I think any kind of an answer to this question really is going to depend very much on the very particular specifics. Okay, let me resort. Can a museum with a federal collection of NAGPRA remains transfer or reinter those remains without consulting the federal agency? Thanks for the answer provided. No is the answer in 2 comments, and I would agree with that. Museum only has custody, but does not have possession or control, and a museum is responsible for notifying the federal agency of the collection by January 13th, I will say, of 2025. There is a new requirement in the regulations that museums with federal collections notify the federal agency within 1 year or by January of 2025. And it is the federal agency that has responsibility to transfer or reinter those remains, not the museum. And the follow-up is, what happens if a museum moves forward without contacting the federal agency? Well, again, if moving forward means publishing a notice of inventory completion for human remains or cultural items, for human remains or associated funerary objects, then in publishing that notice of inventory completion, the museum is asserting that it has possession or control. Now, a federal agency may disagree with that decision by a museum, but in publishing a notice of inventory completion, that is what the museum is essentially doing. Really, in completing an inventory, a museum is saying that it has possession or control. And the options for a federal agency in objecting to that or opposing that decision, I would leave to the federal agency and its own attorneys and how that process might work. Again, depending on the federal agency's disagreement with the museum in terms of beyond just possession or control, but if the federal agency disagrees with the determination of cultural affiliation, then the federal agency may have a reason to question the museum's decision there. But I would leave that to the federal agency and to its own legal advisors to decide whether or not they should proceed. But again, a museum cannot transfer or reinter human remains without publishing 2 notices in the Federal Register. And again, by publishing those 2 notices, the museum is saying it has possession or control. So I want to be very clear that the question for a museum to move forward without consulting a federal agency would mean that the museum is making very clear statements that it doesn't need to work with the federal agency because it has possession or control. Okay. Next question. You noted that there is no process for transfer or reinterment of unclaimed cultural items under subpart C based on the definition. Is that is the same true under subpart B, or is the option to transfer or reinter possible for unclaimed human remains and cultural items under subpart B? Again, subpart B being protection on federal or tribal lands. Thanks for the question, because the answer is yes. The unclaimed human remains or cultural items in subpart B is broader, again, because the obligation is to identify cultural affiliation, or where there is no cultural affiliation or Aboriginal land when we're talking about subpart B, then those items are unclaimed human remains or cultural items under subpart B and can be transferred or reinterred. Now, they would still need to meet a definition, meaning that there might be a need to identify some connection to a federally recognized tribe, but they could still be unclaimed if a federal agency cannot identify a priority Indian tribe. It's a little bit different, and it's worth noting, and it's important to point out. And it goes to the overall purpose of NAGPRA and what Congress was doing when it passed NAGPRA in 1990 with regard to any Native American human remains or cultural items that are discovered or excavated on federal or tribal land. And that is, those do not become collections of the federal government. Rather, human remains or cultural items removed from federal or tribal land must go through the disposition process and identify a priority tribe. And where a priority tribe cannot be identified, then they would be reported as unclaimed. They still need to meet the definition, though, which is the kind of catch here, and it's a little difficult to describe in the abstract. I think that in looking at a specific case where a specific item were removed from federal land and no cultural affiliation can be identified for that cultural item, the federal agency would need to engage in some pretty clear decision making when it decided to transfer or reinter that cultural item as a cultural item, even though it could not identify any cultural affiliation. So I will again say this is a great issue for raising with a specific case, with a specific example. And in that case, the federal agency should be working very closely with its attorneys to make that decision. And the reason for that, I'll just say, is because NAGPRA is not the only law, right, that a federal agency and a federal land manager has to follow. And so if an archaeological resource is removed from federal land, there are other requirements if that is not human remains or cultural items under NAGPRA. And so a federal agency needs to be very careful in its decision making that it's considering all of the authorities that it's hopefully that makes sense. All right, the next question at the top of my list is, does that mean that human remains and AFOs can only be claimed under national NAGPRA, so federally recognized tribes only, but cultural items, UFOs, sacred patrimony, can be claimed under Cal NAGPRA to a non-federally recognized tribe, but only if the recognized tribe doesn't claim it? The answer to this question is the answer to this question is you need to look at the language here, because if it's a cultural item under NAGPRA, meaning a sacred item or an object of cultural patrimony, it has a connection to a federally recognized tribe to meet the definition. So we would actually say it's not that it can be claimed under Cal NAGPRA and not NAGPRA. We'd say it's not NAGPRA. And if items in a museum collection are not subject to NAGPRA, then I can't tell you what happens with them. That goes to the museum's own policies and procedures for its collection and whether it can transfer that collection or deaccession that collection. And there are state, like Cal NAGPRA, perhaps there's state processes that dictate what a state museum can do with collections. But I can't speak to that. All I can tell you is the decision point here is not about whether or not they're claimed, it's whether or not they fall under NAGPRA as NAGPRA cultural items or not. And that's an important decision-making step that is subject to challenge by somebody who does claim that they are. So I want to be very clear that, in deciding an object is not subject to NAGPRA is a decision that NAGPRA does not apply, and you want to be sure that nobody's going to object to that decision. All right, it looks like we have about 15 minutes left, and it's good because I've almost run out of water. And my throat is getting very dry. So, all right. Do non-federally recognized tribes need permission from federally recognized tribes to access or grant permission to display their cultural materials? Great question. Thank you very much. It's one we've received quite a bit lately. As many of you are aware, the regulations did include a new requirement for a duty of care. We've addressed this in a previous webinar, and we've received a lot of questions related to the duty of care requirements. One part of the duty of care requirements, and I want to stress it's only one part, is that human remains and cultural items cannot be accessed, exhibited, or researched without consent from a lineal descendant, Indian tribe, or NHO. So where human remains or cultural items are subject to NAGPRA, so Native American human remains is one we could sort of use as an example. Native American human remains, even if they might be connected to or related to an Indian group without federal recognition, those need to be protected under that duty of care requirement for access and would require consent prior to allowing access. Now, cultural items, again, it's going to come back to that decision about whether or not they are cultural items in the first place, whether or not they can then be accessed or displayed. But again, consent under duty of care related to access, exhibition, or research, consent can only be given by a lineal descendant, Indian tribe, or NHO. All right, the next question. A state with no federal tribes, no tribal land, and no claims made after a notice has been given in 30 years, and there is a state law permitting repatriation to a state tribe. Can they proceed after notice is given to the federal tribes? Well, again, a little insight into how my mind works here and some of the language important here. If we're talking about human remains, and human remains are removed from a state where there are no federally recognized tribes in the state. And I want to point out that that itself does not mean there are not culturally affiliated tribes. So the presence of a tribe today does not equate to cultural affiliation. So there are many states, of course, where Indian tribes were removed and are culturally affiliated to those places and to those human remains, even though they don't inhabit the state today. Putting that aside for a minute, if there are human remains and there is no cultural affiliation, let me change the question to that. Where human remains have no cultural affiliation and a notice of inventory completion has been published, and I would want to verify that that notice of inventory completion was published. But if a notice was published, and it's been 30 years since that notice was published, which again, I would have some questions about because we didn't really have a way of publishing that notice before these new regulations. But if that's all true, and there's a state law that allows repatriation to a state tribe, then the museum would want to look at a process of transferring to a different federally recognized tribe or proceeding with the reinterment themselves under the new regulations. So I kind of broke that down, and the question includes some additional questions for me. But again, for human remains and cultural items, the decision point is cultural affiliation. And if there is no cultural affiliation and that notice gets published to say there is no cultural affiliation, then to follow the federal law, you couldn't repatriate to a state tribe as a resolution, even if state law permits it. You would need to follow the federal requirements to either transfer to an Indian tribe without cultural affiliation to a federally recognized tribe, or to conduct the reinterment by the museum itself. Okay. Can agencies transfer custody to tribe for ancestors and belongings held in museums if they have the consent of the potentially affiliated tribes while they finalize the NAGPRA process to repatriate? Can agencies transfer custody to tribes for ancestors and belongings held in museums? Well, let me step back here and say that a federal agency has possession or control. It can direct what happens to those ancestors or objects. And if the federal agents, I'm inserting federal here, but it could apply to state agencies as well. If a museum, it only has custody of a collection, but it belongs, i.e. it has somebody else has possession or control, then that entity with possession or control can decide what happens to that collection, and that could include moving that collection from one place to another. Now, is there a duty of care requirement here, and is there a consent requirement? We've addressed this in our frequently asked questions around duty of care, and I would point you to that, and especially the question about whether you can move a collection without consent. Because that's really what the question is getting at is, can a collection be moved, or does moving a collection require consent? It's I would say it's a question a museum need, in this case, the federal agency or state agency, the entity with possession or control needs to carefully consider. For that matter, the museum that has custody needs to carefully consider if it were to move a collection, why it was moving the collection. Remember, there's an obligation to care or safeguard a collection. The requirements for access, research, and exhibition are only one part. The other parts are important too of duty of care. And safeguarding, physical safeguarding of a collection is important and is a part of the duty of care. And so if moving a collection is a part of that protection, then there could be a justification for it. Now, when is consent required before moving a collection? That gets into a little bit more of sort of why you're making the decision to move it. What is the protection you're seeking through the move? I would say that what you're talking about here is moving a collection. As much as you're saying transfer, certainly we've seen any number of collections be transferred from one repository to another. We've seen collections be transferred for purposes of repatriation. And so I want to stress again that the duty of care is limited to access, research, and exhibition, and access may or may not include movement. It's going to depend in large part on the reasons for the move. I hope that answers the question. Okay, let's see. We've got about 6 minutes left. It's a good time to ask your questions or upvote those questions if you've got one that I haven't answered yet. It looks like the next upvote, I'll go to this one that doesn't have an answer yet, and that is, how does a federal agency arbitrate and arrive at a final decision with respect for disposition with competing claims for cultural affiliation from different tribes? If the preponderance of evidence suggests cultural affiliation with a non-federally recognized tribe that is being represented by a federally recognized tribe, would preference be given to the competing claims by the other federally recognized tribes? Whew, there's a lot here, but I'll try to parse it apart. We have provided for a priority order where there are competing claims or competing requests. And again, claims relate to disposition on federal land, and requests relate to repatriation by museums and federal agencies. So we use those terms in different parts intentionally. So where there's a claim, a competing claim or a competing request in 10.3, we have outlined a priority order for resolving competing requests. And it would be up to the federal agency in that case to identify who is the most appropriate claimant or requester, if they can do so. And that's going to depend on how the identification of cultural affiliation was made. It has nothing to do with a connection or a relation to an Indian group. So again, a decision about priority order for cultural affiliation is going to depend on how the decision for cultural affiliation was reached, what information is available, and if who is the most appropriate claimant or requester. And it may be, at least in the case of a repatriation request, that a museum or federal agency can't make that decision. And so I hope that answers the question, but we've tried to provide that guidance again in 10.3, cultural affiliation, and it is not related to any connection to an Indian group that is not recognized. The next question is, how should one report summaries of Alaskan Native cultural items when only culture is known? I know that it has been clarified that Alaska Native regional corporations are not federally recognized tribes. Does NAGPRA reporting have to go to each Native village, or can regional corporations have a role under ANCSA? Native Alaska corporations, Stephen Simpson, the solicitor's office, has provided an answer, are Indian groups without federal recognition for NAGPRA purposes. And with any other such group, the Alaska Native Corporation can partner with the federally recognized tribe for repatriation. And the clarification is that I'm speaking about the 227 Native entities within the state. If the regional corporations can assist with contacting those villages. Yeah, I think, let me try to clarify this one a little bit. I don't mean for consultation and reporting itself, but I don't mean consultation and repatriation, but for reporting NAGPRA, for NAGPRA reportings. Well, I guess I would say that there's not a difference under NAGPRA between reporting and initiating consultation. Anytime you're going to reach out and contact a tribe under NAGPRA, it's going to be to initiate consultation. And so where you have objects from Alaska, you may, in fact, need to identify and initiate consultation with the Indian tribes, meaning all 227 Alaska Native villages that are on the list of federally recognized tribes. That is entirely possible. Again, much like Hawaii, hopefully you have additional information that's going to limit it or narrow it down based on location, geographic information. And where you have that geographic information beyond the state, then you should be able to narrow it down to which Alaska Indian tribe to contact. I want to stress here that while regional corporations could be notified in addition, your obligation under NAGPRA is to initiate consultation with the federally recognized Indian tribe, which is the 227 tribes that are listed in the Federal Register in Alaska. If, you know, I think, again, there are lots of museums that have experience and expertise in working in Alaska and might be able to help you identify more regionally the items in your collection. But the obligation is to initiate consultation with the Indian tribe, not the corporation. All right, I'm going to go to the last question for today, and it does relate to our topic. If we determine through a notice of inventory completion that human remains have no lineal descendants and no cultural affiliation, is a museum required to transfer or reinter the remains? No. It is a discretion on the part of the museum to transfer or reinter. They do not have to agree to proceed with transfer or reinterment. So there's a follow-up to that, which is that's where the notice would come into play. And yes, that's correct. You would have to publish a notice before you did transfer or reinter. But the choice to agree to transfer or reinter is a discretionary action by the museum. And the follow-up is there a standard form for a notice of reinterment? We are working on a template for that. We don't have one available yet on our website, but we have been working on that, and we hope to soon. You can look back and see other notices of reinterment that were published under the previous regulatory framework, and the template will be similar to that. If you are ready to proceed with that right now, then reach out to our office and we can assist you. But again, remember, before you can do that, that notice of inventory completion must be published. All right. I thank you all again for your time today and your attention. I appreciate everyone who assisted with answering questions. And I look forward to seeing you all just in a few short weeks on August 2nd for our next webinar. Thank you very much.